My grandmother was buried on a Tuesday. By Thursday, my brother was already accepting congratulations about the waterfront house. I want to tell you about that gap, because everything that matters happened inside it. The funeral was small. 40, maybe 50 people. Grandma had outlived most of her friends, so the crowd was mostly family. Cousins, neighbors, the pastor who had known her for 30 years. The kind of gathering that should have felt like a quiet goodbye. It did not feel like a quiet goodbye. My mother, Margaret Carter, moved through the room the way she always moved through rooms, with the energy of someone who had already decided what everyone else needed to know. She was dressed in dark gray, not black. She had strong opinions about black. I was standing near the back, speaking to Grandma's neighbor, Mrs. Okafor, when I heard the word estate float across the room. I turned. My mother was speaking to two cousins I rarely saw. Her voice was low but controlled. She wasn't whispering. She wasn't hiding anything. Ruth made her wishes very clear, she was saying. She wanted the bulk of the estate to go to Jason and Nicole, the children who were actually present for her in her final years. One of the cousins nodded slowly, the way people nod at funerals, not because they agree but because they don't know what else to do. I stood still. 7 years. 7 years of tax documents and medical appointments and home repairs and banking calls and prescription pickups and contractor scheduling and insurance paperwork. 7 years of driving 40 minutes each way twice a week, sometimes more. And my mother had just described me as someone who was not present. At my grandmother's funeral, with my grandmother's pastor standing 12 feet away. I said nothing. Within an hour, the dynamic had shifted in a way I can only describe as architectural. Jason was suddenly the center of every conversation. He was accepting condolences about Grandma while simultaneously fielding questions about the waterfront property, what he planned to do with it, whether he would renovate, whether he would sell. He spoke about the house with the casual confidence of someone who had already signed paperwork. He had not signed any paperwork. Grandma had been dead for 4 days. Nicole, my younger sister, was moving through the room with a specific kind of performance I recognized from childhood. The soft smile, the grateful eyes, the careful mention of how close she and Grandma had been in the end. She said the word, Grandma, the way people say the name of someone they are claiming. No one spoke to me about the estate. Not once. One cousin, my father's side, found me near the refreshment table and said in a voice designed to be kind, "At least you have your career, Emily." Thanked him. I did not say anything else. 3 months before she died, Grandma had called me on a Wednesday afternoon. I remember because I was finishing a 12-hour shift and almost didn't pick up. She said, "Emily, I need you to promise me something." I told her I was listening. Don't ever let anyone pressure you into giving up what you've earned. Not family. Not anyone. You keep what's yours. At the time, I thought she was talking about self-respect. About the way I had a habit of backing down from arguments to keep the peace. Grandma had noticed that about me for years. I told her I promised. She said, "Good. I've taken care of it." I didn't ask what she meant by that. I wish I had asked what she meant by that. I left the cemetery just before 4 o'clock. My father walked me to my car. Richard Carter. A quiet man who had spent 40 years agreeing with my mother and calling it keeping the peace. He hugged me and said he was sorry it had worked out this way. I asked him what he meant. He looked at the ground. He said, "Your mother did what she thought was best for the family." He got back in the car before I could respond. I was almost to the highway when I remembered something. 4 years ago, Grandma had pressed a folded piece of paper into my hand during a Sunday visit. She told me to put it somewhere safe. Inside the old blue photo album, she said. The one with the silver clasp. I had done exactly that and never looked at it again. I had assumed it was a recipe. Or a phone number. or something belonging to the category of small things elderly women ask you to hold on to. As I was leaving the cemetery, I remembered that piece of paper. I thought about the way Grandma said I've taken care of it. I thought about my brother accepting congratulations about a house that hadn't been transferred yet. Suddenly, that folded piece of paper felt like the most important thing she had ever given me. I found the blue photo album exactly where I had left it. Top shelf of my hall closet, behind a box of medical textbooks I hadn't opened since nursing school. The silver clasp was tarnished. The spine had started to separate. I set it on the kitchen table and sat down in the kind of silence that follows funerals. The silence where the house feels too still and every small sound feels too loud. I opened it. The photographs inside were exactly what you'd expect. Grandma at holidays. Grandma at birthdays. Grandma in the backyard of the waterfront house, squinting into the sun, looking younger than I ever remembered her being. I turned pages slowly, not rushing. The folded paper was tucked between two photographs near the back. I recognized Grandma's handwriting immediately, the careful, slightly slanted cursive she used for anything she considered important. But this wasn't her original handwriting. It was a photocopy. She had copied a page from something and folded it here deliberately. I read it once. Then I read it again. Then I set it flat on the table and stared at it for a long moment before I understood what I was actually looking at. The page was from a journal. One entry. Dated. Signed with her initials the way she always signed personal notes. The entry said in plain language that the waterfront house was intended for Emily. That Emily had earned it. That she wanted this recorded somewhere safe because she was beginning to feel uncertain about the paperwork being handled on her behalf. She had written the word uncertain. Not suspicious. Not alarmed. Certain. Grandma had always been careful with language. She chose words the way she chose everything else. Deliberately and without waste. I noted the date. Then I sat back in my chair. Because the date on that journal entry was 4 years before she died. I am a registered nurse. My entire professional life is built on pattern recognition. You learn after enough years in that work that isolated incidents are rarely isolated. You learn to look backward before you look forward. So I looked backward. 4 years ago. What was happening 4 years ago? Grandma had been healthy enough. Slower than she used to be, but sharp. She still managed her own calendar. She still called me directly when she needed something. And then gradually she didn't. The calls started coming through my mother instead. Margaret would phone to let me know Grandma needed a prescription picked up. Margaret would relay that Grandma wasn't feeling up to visitors that weekend. Margaret would explain that the financial paperwork was being handled and there was no need for Emily to drive out. I had accepted every one of those explanations. At the time, I told myself my mother was finally stepping up, doing her share. I was wrong to tell myself that. I started writing a timeline on a legal pad. Old habit from nursing. When something doesn't add up, you write the sequence down and look at it in order. The pattern that emerged was not subtle. Year 1 of the 4-year window. Margaret begins positioning herself as the primary contact for Grandma's affairs. Phone calls are rerouted. My direct access quietly narrows. Year 2. I arrive for a Sunday visit and find Margaret already there with a folder of documents. The conversation stops when I walk in. My mother says they were just going over some routine paperwork. Grandma smiles and says nothing. Year 3. I notice Grandma seems confused about a banking matter we had discussed the previous month. She references a decision I have no memory of. When I try to clarify, she becomes flustered and changes the subject. Year 4. The calls from Grandma stop almost entirely. I had told myself she was slowing down. That she needed less from me. That the distance was natural. Every one of those explanations had felt reasonable in isolation. Written on a legal pad in sequence, they told a completely different story. I looked at the photocopied journal page again. The date matched year one of that window exactly. The year my mother started handling Grandma's legal paperwork. The year direct access to Grandma became something that had to go through Margaret first. Grandma had written that entry at the precise moment the isolation began. She had made a copy. She had hidden it. She had placed it in my hands 4 years later with no explanation beyond put this somewhere safe. She wasn't asking me to hold a recipe. She was building a record. The journal entry was dated 4 years before Grandma died. What frightened me wasn't what she wrote. It was the fact that the date matched the exact year my mother started handling all of Grandma's legal paperwork. Probate records are public documents. Most people don't know that. They assume estate filings are sealed behind legal privilege, accessible only to attorneys and direct parties. They're not. In most jurisdictions, once a will enters probate, the filings become part of the public court record. Anyone can request them. I requested them. I told no one. Not a friend. Not a colleague. I drove to the probate court on a Wednesday morning, filled out a records request form, and waited 40 minutes while a clerk located the file. When she handed me the folder, she asked if I needed a copy station. I said yes. I copied everything. I read through the documents that evening at my kitchen table, the same place I had read Grandma's journal entry 2 days earlier. I had a highlighter, a legal pad, and the timeline I had already started building. The first document was the original will, dated 11 years ago. It named Emily Carter as the primary beneficiary of the waterfront property and the majority share of the estate. The language was clear. The signatures looked consistent with Grandma's handwriting across other documents I had seen over the years. Then came the amendments. There were 3 of them filed across a 4-year window. Each one reduced my share. Each one redistributed assets toward Jason and Nicole. By the final amendment, I had been reduced to a nominal amount, a small savings account and a piece of jewelry. I read each amendment twice before I picked up my highlighter. The first thing I marked was the witness signatures. Legal documents require witnesses for a reason. A witness confirms the signing party was present, competent, and acting without coercion. Their information, name, address, signature, is supposed to be complete and verifiable. On the original will, both witness lines were fully filled out. Printed names. Legible signatures. Dated. On the First Amendment, one witness line was incomplete. The printed name was there. The signature was a compressed scrawl that didn't match the printed name in any obvious way. The date had been filled in with a different pen than the rest of the document. Slightly darker ink, slightly different pressure. I noted it. Moved forward. The Second Amendment had similar irregularities. A witness whose printed name appeared on no other document in the file. An address line that was partially filled in, then corrected with the correction initialed by no one. The Third Amendment, the final one, the one that reduced me to almost nothing, had a witness signature I could not read at all. Not a scrawl. Not compressed handwriting. Simply a mark that began as a letter and resolved into nothing. I set down my highlighter, because that was when I noticed the name of the estate planner. He was listed on all 3 amendments as the preparing attorney. His name appeared on the letterhead of the Third Amendment, the most significant one, with a firm address and a bar number. I wrote his name on my legal pad. Then I searched for him. The search took 4 minutes. He had retired from practice 11 months before the Third Amendment was supposedly prepared and executed. There was a brief announcement on the State Bar's website. Routine retirement notice, effective date clearly stated. His license was listed as inactive. The firm address on the amendment was the same address he had vacated when he closed his practice. His name was on a document dated 11 months after he had stopped practicing law. His bar number was attached to work he could not have performed. I sat with that for a long moment. Then I wrote one word on my legal pad. Fraud. Not favoritism. Not manipulation. Not a family pushing paperwork in a direction that benefited them. If the preparing attorney's name and credentials appeared on a document executed after his retirement, someone had placed them there. Someone had used his identity to lend legitimacy to an amendment he had never seen. That was a different category of problem entirely. I pulled the Third Amendment back to the top of the stack and read it again from the beginning. Slowly this time. Not looking for patterns. Looking for anything I had moved past too quickly. I found it on page 4. Each page of a legal amendment is typically initialed by the signing party. A standard practice confirming the signatory reviewed every page, not just the final signature line. Pages 1 through 3 carried Grandma's initials in the bottom right corner. The same careful, slightly slanted style I recognized from decades of birthday cards and grocery lists and the journal entry she had hidden inside the photo album. Page 4 had initials too, but they were not hers. The letters were upright. Printed not cursive. Pressed into the paper with the flat confidence of someone who initialed documents professionally. Not the careful, deliberate mark of an 81-year-old woman who had been signing her name the same way for 60 years. I was staring at the amendment when that detail caught my eye. Someone had initialed a page in a style Grandma had never used in her entire life. I made a decision that night that I have never regretted. I was not going to confront anyone. Not my mother. Not Jason. Not Nicole. Not my father, who would have apologized quietly and then reported every word back to Margaret before I reached my car. Here is what 25 years of nursing teaches you about high-stakes situations. The moment you announce that you know something is wrong, the people responsible stop making mistakes. They get careful. They get attorneys. They begin managing the story instead of living inside it carelessly. My family had been careless for years. I intended to let them stay that way. The call started about 10 days after the funeral. Jason called to let me know he was having the waterfront property assessed. He mentioned it the way you mention a dentist appointment. Routine already scheduled, not a question. He said he wanted to get the process moving before the estate dragged on too long. He used the phrase "my property" twice in a 4-minute conversation. I told him that sounded reasonable. I wrote down the date and time of the call immediately after we hung up. Nicole called 3 days later. She wanted to discuss Grandma's jewelry collection. Specifically, she wanted to know whether the pearl set had already been cataloged by the estate, because she had always understood those pieces were meant for her. She said Grandma had promised them to her. I asked when that conversation had happened. Nicole paused just long enough to be interesting. Then she said it had been years ago, that she couldn't remember exactly when. I told her I understood. I wrote that down too. My mother sent a text rather than calling. It said, "The attorney will be in touch about the small account left to you. Hopefully this can all be resolved without any unpleasantness." I read it 3 times. The word unpleasantness was doing a great deal of work in that sentence. It was a warning dressed as courtesy. My mother had been issuing that particular kind of warning my entire life. The gentle reminder that making noise would cost me more than staying quiet. She had always been right about that before. I did not respond to the text. Instead, I filed it with the timeline on my legal pad and moved forward. I submitted a records request on the waterfront property the following morning. I had already pulled the probate filings. Now I requested the property transfer history on the waterfront house, along with any liens, encumbrances, or financing inquiries attached to the parcel number. What came back was more than I expected. The property itself was clean. No liens, no transfers. Grandma had owned it outright for decades. But attached to the parcel record were inquiry notations. Lender inquiries. The kind generated when someone approaches a financial institution and begins discussing a property as collateral or future asset. There were 2 of them, both connected to Jason Carter. The first was dated 14 months before Grandma died. The second was dated 9 months before she died. I want to be precise about what that means. A lender inquiry attached to a property you don't own yet means you have approached a financial institution and represented that property as part of your expected financial picture. You have described yourself in some capacity as its future owner. Jason had done this not once but twice. While Grandma was alive. While she was still living in that house. I requested the underlying documentation on both inquiries. One came back quickly. A preliminary financing consultation, the notes sparse but clear. Jason had described the waterfront property as an asset he expected to inherit. He had provided an estimated value. He had used it to support a loan conversation that ultimately did not proceed. The second file took longer to arrive. When it did, I sat down before I opened it. The second lender's file was more detailed. The consultation had gone further. Jason had provided not just an estimated value but a timeline. He had told the lender he expected to take ownership within the year. He had described the property in terms specific enough that the lender had begun preliminary title research. On Grandma's house. 9 months before she died. There was a notation in the file. A brief summary line written by the loan officer recording the conversation. It said, "Borrower states property is currently occupied by elderly relative, ownership expected to transfer upon passing." My brother had sat across from a lender and described our grandmother as an elderly relative whose passing would resolve his financial problems. 9 months before she died. One lender's file contained a statement that made my stomach drop. My brother had already been describing himself as the future owner of Grandma's house nearly a year before she died. I had started this with a folded piece of paper hidden inside a photo album. Now I had probate filings, amendment irregularities, a retired attorney's name on documents he couldn't have prepared, initialing that didn't belong to my grandmother, and a lender's file proving my brother had been circling her house like a creditor before she was gone. That should have been enough to bring to an attorney. It wasn't enough for me yet, because I kept coming back to one question I hadn't answered. If the estate amendments were fraudulent, someone had to pay for them. Legal documents, even forged ones, don't prepare themselves. Notarizations cost money. Filing fees cost money. And if someone had been substituting pages inside estate planning meetings, those meetings had to be arranged and funded through something. I wanted to know where the money came from. As Grandma's unofficial caregiver for 7 years, I had helped her organize her finances more times than I could count. I knew the name of her bank. I knew the type of accounts she held. I knew that she kept meticulous paper records in a green accordion folder in the second drawer of her home office desk. I had returned that folder to her home after the funeral along with other personal items the family had asked me to retrieve. I had made copies of everything inside it first. The habit of keeping records had started as professional instinct. In the weeks since the funeral, it had become something more deliberate. I spread the bank statements across my kitchen table in chronological order. Nearly 3 years of them. And I started at the beginning. The first year was clean. Grandma's income came in. Her expenses went out. Utilities, groceries, medical copayments, the property tax installment she always paid in 2 halves. Nothing irregular. The account behaved exactly the way the account of a careful, financially responsible woman in her late 70s should behave. The second year was when the transfer started. Small at first. $400 in March. $600 in July. $350 in September. each one categorized in the memo line as family assistance or personal gift, or in 2 cases, left entirely blank. I noted each one and kept reading. By the 3rd year the amounts had grown. $1,200 in February, $2,000 in April, $1,500 in June. Then in August of that year a single transfer for $8,000. Memo line blank. Destination account number partially visible on the statement before routing to an external institution. I wrote the partial account number on my legal pad. Then I added up everything I had highlighted. Across 31 months, $42,300 had left my grandmother's accounts in transfers that did not match any bill, any known expense, or any charitable giving pattern she had maintained for years. I thought that was the smoking gun. I was not finished yet. During the caregiving years, I had occasionally helped Grandma manage her email, setting up her tablet, resetting passwords, organizing her inbox when it became overwhelming. She had given me her login credentials and told me to write them inside the back cover of her address book. She had never asked for them back. The address book was in the green accordion folder. The credentials still worked. I want to be precise. I was not searching for anything specific. I was looking at an account belonging to a deceased woman whose estate I was a named party in. An estate I had documented reasons to believe had been tampered with. I was looking for financial correspondence. What I found was not financial correspondence. It was an email chain between my grandmother's account and my mother's personal email address, spanning several years. Most of it was ordinary. Appointment reminders, grocery requests, the routine back and forth of a daughter managing an aging parent's schedule. But one email sent from my mother's account 4 years before Grandma died was not routine. The subject line said, "Question for you." The body of the email said this, and I am recounting it precisely because I read it many times. I spoke with someone at the firm today. I asked how difficult it would be to update the beneficiaries on mother's accounts without upsetting her. He said it depends on the documentation. I think we should discuss this before the next appointment. 4 years before Grandma died, my mother had been asking an estate firm how to change beneficiaries without my grandmother knowing. The email was dated 3 weeks before the first suspicious amendment appeared in the probate file. I set the laptop aside and looked at my legal pad. The timeline was no longer a theory. It was a sequence. Email first. Amendment 3 weeks later. Transfers beginning shortly after. Lender inquiries from Jason running parallel. A retired attorney's name appearing on documents prepared after he had closed his practice. Each piece connected to the next. I had enough to bring to a probate attorney. I had made that appointment already for the following week. But before I could get there, something happened that I had not anticipated. I had sent a quiet inquiry to the estate planning firm listed on the original amendments. Not the fraudulent ones, the original. I had asked, without explaining why, whether any former staff members from that period might be willing to speak with a family member about their experience. 3 days later my phone rang. A woman introduced herself as a former legal assistant at the firm. She said she had received my inquiry. I asked if she remembered anything about my grandmother's estate meetings. There was a pause. Then she said 5 words that reframed everything I thought I already knew. I remember that meeting perfectly. Her name was Carol Briggs. She had worked as a legal assistant at the estate planning firm for 11 years before leaving to take a position closer to home. She was not angry. She was not looking for attention. She was a careful, soft-spoken woman who had spent a decade organizing documents for other people's most sensitive moments. And she remembered my grandmother's file because something about it had bothered her for years. She said that on the phone before we even scheduled a meeting. She said, "I never knew what to do with what I saw. I didn't think anyone would believe a legal assistant over a family. I told her I would believe her. I told her I had documents. She went quiet for a moment. Then she agreed to meet. We met at a coffee shop midway between us. She brought nothing. I brought my folder. She didn't need my documents to remember. She remembered on her own. She told me that during 2 separate estate planning meetings involving my grandmother, she had observed something she had flagged internally but never reported formally. In both meetings, the attorney had stepped out of the room briefly, once to take a call, once to retrieve a file. During those absences, the person accompanying my grandmother had rearranged the paperwork on the table. The person accompanying my grandmother was my mother. Carol described watching Margaret shift pages within the document stack. Not replacing them in front of her. She wasn't certain about substitution at that moment, but reordering them in a way that struck her as deliberate. When the attorney returned, the stack looked identical to how it had been. But the internal sequence had changed. She said my grandmother had signed without reading fully, that she had seemed tired, that she had asked once what she was signing and been told by my mother that it was the same paperwork they had already discussed. Grandma had nodded and signed. Carol had noted it. Said nothing. Told herself she was probably misreading a family dynamic. She had thought about it many times since. I asked her if she would provide a sworn affidavit. She said she had already spoken to an attorney friend about that possibility before calling me back. He said yes. The affidavit was completed and notarized 6 days later. 2 pages. Precise language. Specific dates, specific observations, specific descriptions of what she had witnessed during both meetings. She named my mother by the description she remembered. The woman who accompanied the elderly client and handled the paperwork before signatures were obtained. It was the first piece of evidence that placed my mother's hands directly on those documents. Everything before this had been financial. Circumstantial in certain respects. Patterns, timelines, irregularities. A forensic examiner could argue alternative explanations for inconsistent signatures. A clever attorney could reframe the bank transfers as authorized gifts. Carol's affidavit was different. Carol had been in the room. I had almost forwarded everything to the probate attorney when I received a response to one more inquiry I had sent. This one to the bank where the signing meetings had occasionally taken place for notarization purposes. I had asked, without much expectation, whether archived security footage existed for the relevant dates. The compliance officer who responded told me that footage older than 3 years was typically destroyed on a rolling basis. The meetings Carol described fell just inside that window. 2 of the dates had footage on file. It took 10 days and a formal written request citing my status as a named estate party to obtain access. When I finally sat in front of a monitor in the bank's compliance office and watched the archived footage, I understood immediately why Carol had never forgotten those meetings. The footage showed Grandma seated at a table. Across from her, my mother. Between them, a document stack. What the footage showed, without audio but with complete visual clarity, was my mother positioning herself between the documents and my grandmother's line of sight before each signature page was presented. At one point, Margaret's hand rested across the upper portion of a page while Grandma's pen moved across the signature line at the bottom. Grandma could not see what she was signing. Margaret knew exactly what was on the page. I sat in that compliance office for a long moment after the footage ended. Then I thanked the officer and collected the documentation authorizing the footage for legal proceedings. I forwarded everything to the probate attorney that evening. The full package. Every document. Every record. Every piece of evidence the case required. I sent it without a cover letter. The documents explained themselves. The attorney called me the following morning and asked me to come in. I sat across from him in a quiet office. He had printed everything. The stack in front of him was thick, weeks of my careful silent work compressed into paper and ink. He read without speaking, turned pages slowly, occasionally made a note in the margin. At one point he stopped, went back 3 pages and read something again. When he finished, he set the stack down and looked at me. The room was very still. Then he said in a tone I had not heard from him before, "Emily, did your grandmother ever mention a second envelope?" The probate hearing was scheduled for a Tuesday morning. My mother arrived 12 minutes early. I know because I was already seated when she walked in, and I watched her enter the room with the particular posture she reserved for situations where she expected to be in charge. Shoulders back, chin level. The expression of someone attending a proceeding they considered a formality. She was wearing dark gray again. She sat down without looking at me. Jason arrived next, followed by Nicole, followed by my father, who found a seat at the end of the row and immediately looked at the floor. My brother leaned over to say something to his attorney. Whatever it was, it made the attorney nod. Jason sat back and crossed one leg over the other. He looked like a man waiting to collect something. The presiding officer called the hearing to order and confirmed the parties present. Routine opening. Routine language. My mother's attorney made a brief statement affirming the validity of the estate amendments and requesting an orderly distribution proceeding. The probate attorney, my grandmother's original attorney, the one who had called me about the second envelope, waited until that statement was finished. Then he placed a document binder on the table. It was thick, tabbed, organized by date. He said he needed to present material relevant to the integrity of the estate documents before any distribution could be addressed. My mother's expression did not change. Not yet. He started with the email. He read it aloud, not in full but the operative sentence, the one where my mother asked an estate firm how difficult it would be to update beneficiaries without upsetting her mother. He stated the date. He stated the sender. He stated the recipient. My mother's attorney was on his feet immediately with an objection about context. The presiding officer asked for the full chain to be submitted into the record and noted the objection. The email was entered. Then came the bank statements. $42,300. 31 months. 42 transfers. The attorney presented a summary chart. Amounts, dates, destination account classifications. He noted that none of the transfers corresponded to any documented expense, authorized gift record, or known charitable contribution in my grandmother's financial history. He noted that several transfers occurred within days of meetings where estate amendments had been presented for signature. Jason uncrossed his legs. The lender's files came next. The attorney described the 2 financing inquiries Jason had initiated against the waterfront property while my grandmother was still living in it. He quoted the loan officer's notation directly, the one describing the borrower's expectation that ownership would transfer upon the passing of the elderly relative currently occupying the home. Jason's attorney made a sound that was not quite an objection and not quite a response. Jason said nothing. Nicole had stopped looking at the table and was now looking at the door. The property filings followed. The preliminary title research the second lender had initiated based on Jason's representations. Additional documentation confirming Jason had described himself as the future owner across 2 separate financial institutions before his grandmother's death. The room was quieter than it had been 20 minutes earlier. My mother's expression had shifted, not collapsed but tightened. The confidence was still there, but it had become effortful. The kind of expression that requires maintenance. Carol's affidavit was read into the record in full. 2 pages. Every detail she had described to me in that coffee shop, rendered now in sworn legal language. The meetings. The document rearrangements. My mother positioning herself between the paperwork and my grandmother's line of sight. The moment Grandma asked what she was signing and was told it was paperwork they had already discussed. My mother leaned toward her attorney and said something in a low voice. Her attorney held up one hand, a small, quiet gesture that meant not now. The security footage was presented next. The attorney described what the footage showed in precise, measured terms. Margaret's positioning at the table. Her hand across the upper portion of the document. My grandmother signing the bottom of a page she could not fully see. He noted the dates. He noted the filing dates of the amendments that followed those meetings. He noted that they matched. My mother stopped maintaining the expression. Then the forensic handwriting report arrived. The analyst had examined the initialing on page 4 of the final amendment. The upright, printed marks that bore no resemblance to the careful cursive my grandmother had used her entire life. The report concluded with the measured certainty that forensic analysis allows. The initialing on page 4 was inconsistent with all verified samples of the decedent's handwriting across a 12-year comparison window. The page had not been initialed by my grandmother. Someone else had initialed it on her behalf. The report did not name that person. Didn't need to. My mother's face, for the first time in the proceeding, said everything she was not saying out loud. Every explanation her attorney had prepared for individual pieces of evidence now had to account for all of them simultaneously. The email. The transfers. The lender files. The witness. The footage. The forensic analysis. The retired attorney's name on documents he could not have prepared. There was no arrangement of words that covered all of it. I had believed that was the end of it. That the forensic report was the final piece. That the presiding officer would adjourn to consider findings and we would wait for a ruling. I was wrong. The attorney reached beneath the evidence binder. He removed a sealed envelope. The envelope was covered in my grandmother's handwriting. Her name for the attorney in the upper left corner. A date written along the seal, and on the front, in her careful slanted cursive, a single instruction. He held it up so the room could see it. Then he said, "There is one final instruction from the deceased. If this story stayed with you, hit subscribe and turn on notifications. Every week there's a new story. And drop a comment below. Have you ever watched someone rewrite the truth right in front of you? Tell me. I read every single one." The room did not make a sound. The attorney held the envelope for a moment, not for effect, but because the instruction on the front required him to read it aloud before breaking the seal. Grandma had written it herself in the same careful slanted cursive she had used her entire life. He read it. The instruction said, "If my granddaughter Emily Carter has been excluded from my estate in any form, this envelope is to be opened publicly and its contents entered into the full record. Not summarized. Read in full." My mother's attorney placed both hands flat on the table. The seal was broken. The envelope contained 4 items. The first was a copy of the original estate plan. The one naming Emily Carter as primary beneficiary of the waterfront property and majority share of the estate. Dated. Witnessed. Signed in the careful cursive I recognized from a lifetime of birthday cards and grocery lists and a photocopied journal page hidden inside a photo album. The second item was a personal letter. 7 pages handwritten. Dated 3 years before Grandma died. The attorney began reading it aloud. Grandma's voice, rendered in his, filled the room. She had written the letter the way she did everything. Without waste, without drama, without a single word that wasn't load-bearing. She described what she had observed. She named dates. She named documents. She described the meeting where she had asked what she was signing and had been told it was paperwork they had already discussed. She wrote that she had not believed that answer but had been too tired to press further, and that she had regretted it immediately afterward. She named my mother by name. She named Jason. She named Nicole. She described the isolation, the phone calls that stopped reaching her, the visits that were suddenly too much for her health, the way conversations about finances ended when Emily walked into the room. She wrote that she had noticed all of it, that she had not been confused, that she had understood exactly what was happening and had not known how to stop it without destroying what remained of her family while she was still alive to watch it happen. So she had done the next best thing. She had documented everything, prepared a contingency, and trusted the one person she knew would eventually look closely enough to find it. The third item was a packet of copies. Copies of the suspicious amendments. Her personal copies, the ones she had obtained and kept without telling anyone. Beside each one in the margins in her handwriting were notations. Dates she remembered. Discrepancies she had noticed. Pages she did not remember signing. Initials she had never made. She had been conducting her own quiet audit from inside the situation. She had seen the same things I had seen. She had simply gotten there first. The fourth item was a single index card. On it, in large letters, she had written the name and contact information of a forensic document examiner she had identified herself and contacted 3 years before her death. The card included a notation in her handwriting. She has already been briefed. She is expecting to be called. Grandma had retained a forensic expert. Before anyone had thought to look for fraud. Before I had found the journal entry. Before I had requested a single probate filing. My grandmother had built the case herself and stored it in a sealed envelope with instructions timed to detonate the moment her wishes were violated. My mother did not speak after the letter was finished. Not a denial. Not an explanation. Not the carefully constructed narrative about correcting an unfair decision that I had heard fragments of for years. She sat with both hands in her lap and looked at a fixed point on the table in front of her that contained nothing. Jason's attorney requested a recess. It was granted. It didn't help. The legal consequences moved quickly after that. The probate court invalidated all 3 amendments. The original estate plan was reinstated in full. A referral for criminal investigation was filed based on the forensic handwriting findings, the document substitution evidence, and the unauthorized financial transfers. Civil recovery actions followed for the $42,000 that had left Grandma's accounts without authorization. Jason's lenders received the court findings automatically through the public record. The financing conversations he had conducted against a property he never legitimately owned became part of a financial disclosure proceeding he had not anticipated and could not manage. Nicole received the small predetermined amount the original estate plan had always designated for her. Nothing more. My mother spent the following 18 months and a significant portion of her own savings on legal defense. I did not follow the details closely. I had already made my decision about contact before the hearing ended. There was no conversation about it. No letter. No final phone call with carefully chosen words designed to make someone understand something they had already chosen not to understand. I simply stopped. Months later, I stood on the porch of the waterfront house on a quiet morning. The water was visible through the tree line the way Grandma had always described it. Silver in the early light, still enough to look painted. Inside, on the wall beside the front door, I had framed the last page of her letter. Not the accusations. Not the names. The final paragraph where she wrote that she had never doubted me. That she had known from the beginning that I would find it. That she had made sure of it. I stood on that porch for a long time. Not celebrating. Not reconstructing every moment I should have seen sooner. Not rehearsing what I would have said if any of them had offered a genuine account instead of a performance. Just standing on the porch of a house that had always been mine. For years they told me I was imagining things. That I was jealous. Difficult. Wanted. That the distance between me and my family was my own fault. A personality problem, a chip on my shoulder, a refusal to accept the way things were. In the end, the last person who truly knew the truth had already prepared the evidence. My grandmother did not leave me a house. She left me proof. The house was just where I keep it,